5 seconds to go. Start. The power to grant stay on the execution proceedings, which would then result into an order for payment of means profit, is what has been described as incidental or subject to the final outcome of the case. This court has observed in G. L. Vijayan versus K. Shankar as under. It must be borne in mind that incidental power is to be exercised in aid to the final proceedings. In other words, an order passed in the incidental proceedings will have a direct bearing on the result of the suit. Such proceedings, which are in aid of the final proceedings, cannot thus be held to be on a par with supplemental proceedings, which may not have anything to do with the ultimate result of the suit. Such a supplemental proceeding is initiated with a view to prevent the ends of justice from being defeated. Supplemental proceedings may not be taken recourse to in a routine manner, but only when an exigency of situation arises. Therefore, the orders passed in the supplemental proceedings may sometimes cause hardships to the other side and thus are required to be taken recourse to when it is necessary in the interest of justice and not otherwise. There are well defined parameters laid down by the court from time to time as regards the applicability of the supplemental proceedings. Incidental proceedings are, however, taken recourse to in aid of the ultimate decision of the suit, which would mean that any order passed in terms thereof, subject to the rules prescribed therefore, may have a bearing on the merit of the matter. Any order passed in aid of the suit is ancillary power. This court in Martin and Harris Private Limited versus Rajendra Mehta, speaking through one of us, J.K. Maheshwari judge, observed that thus, after passing the decree of eviction, the tenancy terminates and from the said date the landlord is entitled for means profits or compensation depriving him from the use of the premises. The decree of the trial court on 3rd March 2016 has been confirmed in appeal, against which second appeal is pending. However, after stay on being asked, the direction to pay means profits or compensation issued by the High Court is in consonance to the law laid down by this court, which is just, equitable, and reasonable. The basis of determination of the amount of means profits, in our view, depends on the facts and circumstances of each case, considering the place where the property is situated, that is, village or city or metropolitan city, location, nature of premises, that is, commercial or residential area, and the rate of rent precedent on which premises can be let out are the guiding factor in the facts of individual case. A perusal of the judgments extracted above, as also other cases where Atmaram properties supra, one common factor can be observed, that is, the decree of eviction stands past and the same having been stayed gives rise to the question of payment of means profit. As observed above, the respondent contends that since in the present case no decree of eviction is passed and there is no stay awarded, the question of such payment does not arise. While the above stated position is generally accepted, it is also within the bounds of law that a tenant who once entered the property in question lawfully continues in possession after his right to do so stands extinguished is liable to compensate the landlord for such time period after the right of occupancy expires. In this regard, we may refer to Indian Oil Corporation Limited versus Sudhera Realty Private Limited, wherein this court in para 64 observed as under. Stop.